The two main forms of co-ownership in Alberta are joint tenancy and tenancy in common. Joint tenancy is a form of ownership that includes what is known as the right of survivorship. When one joint tenant dies, their interest in the property automatically and immediately transfers to the surviving joint tenants. This transfer occurs outside of the deceased's will and bypasses the often lengthy and costly probate process. Because of this seamless transition, joint tenancy is the most common form of the ownership for marriage couples or long-term partners. Tenancy in common, on the other hand, is a structure where each owner holds a distinct, specified share of the property. These shares can be equal 50-50 or unequal 70-30, and each owner can deal with their own share independently. Crucially, there is no right of survivorship. When a tenant in common dies, their share does not automatically go to the other co-owner. Instead, it becomes an asset of their estate and is distributed according to their instructions in their will or by provincial intestacy laws if there is no will. This means the property interest must go through probate process. A critical point of caution is that under the Land Titles Act, tenancy in common is the default form of ownership. If the transfer of land document does not explicitly state that the new owners are to be joint tenants, the Land Titles Office will register them as tenants in common by default. This can lead to unintended and often undesirable outcomes. Consider a scenario where aging parents decide to add their adult child to the title of their home for convenience, intending for the child to inherit the property easily. If the transfer form is completed without specifying as joint, they will be registered as tenants in common. If that child were to predecease the parents, their 1/3 share in the family home would not revert to the parents. Instead, it will pass to the child's own estate, potentially going to their spouse or even creditors, creating a complex and distressing co-ownership situation for the parents. This demonstrates that the decision of how to structure ownership is intricately linked to estate planning. The question is not simply a legal definition, but a personal one. Who do you want to inherit your interest in this property? And do you want that to happen automatically or through a formal process of your will?